Labor law in Russia is very complicated question, and I'm happy to have you here. We shall speak about labor agreements with foreigners. My name is Natalia Neverovskaya. I'm a lawyer. I work with the international law firm Unicom Legal. This is one of the oldest law firms in Russia, and we have two offices. One office is in Moscow and another office is in St. Petersburg. So if you need to contact us, please feel free to call us or to write us messages. If you need more training, then you can contact the Academy of Open Education, and you can get training also in English language. In Russia, many law firms provide different kind of services to their clients. For example, our company is providing services for corporate clients. We work with companies, and we provide services in commercial, contract law, labor law, arbitration, litigation, real estate, taxes, and so on. We're very strong in labor law. And speaking about labor law, we need to consider that in Russia, the process of employment and dismissal is very regulated procedure. Staff redundancy, one of the way to dismiss personnel, is also very complicated. In Russia, every employer has to create its own documents, in-house rules, which will be the part of labor legislation for particular employer, for particular company. Labor law for foreigners is also very important topic for us. And in case of dispute resolution, we can also be helpful. And should you need to contact with trade unions or resolve some questions with trade unions, we have also very big experience in that. Russian labor law consists not only of the labor code and different governmental acts, but as I already told you, Russian labor law consists of those documents which the employer creates for its employees. Such documents are in-house rules, labor agreement, and other documents which will be very important for labor relationships. When we hire a foreigner, we need to see the passport of the foreigner. Every foreigner may have a labor book, or records about working in Russia will be held in special register. Also, if it's necessary, the foreign employee may show the diploma. In some cases, the employer may obtain work permit for the employee. In some cases, the employee may come with the ready-made work permit. And in some cases, the employee may come with the medical insurance to the company for employment. And in some cases, we can obtain the medical insurance for foreign employee. It depends on the status of the foreign employee, and it depends on the type of the work permit, according to which foreigner will work in the Russian company. We may set the probatory period for the foreign employee. For ordinary employees, the maximum probatory period is 3 months. For top management, the probatory period is up to 6 months. The employer produces a labor agreement, job description, in-house rules, and different other internal documents, provision on salary, provision on commercial trips, provisional person, personal data processing, and so on. Normally, the agreement is done for indefinite period of time. Even if we hire a foreign citizen, we have very limited possibilities to make the agreement for fixed term period. Only if the employee comes to work for certain project, or if the employee comes to work for seasonal work, and in some other rare cases, we can fix the term of the agreement in the labor contract, and in any case, this time of employment may not exceed 5 years, just if we make the agreement for fixed term period. In the labor agreement, we need also to set exact amount of salary. The salary must not be less than minimum amount of wage which is set by the government of the Russian Federation every year. Salary must be paid not less than twice a month. Standard working time is 8 hours per day and 40 working hours per week. But in some cases, another length of working time may be considered. Every employee must have annual vacations. Minimum days for annual vacations is 28. If the employee is sick, then the employee must provide sick leave to the employer. Normally, in current time, it is done automatically because the social insurance fund sends the sick leave of the employee automatically to the employer. So the employee mustn't do any extraordinary work. Work permit normally is issued for the period of 1 year, but if we speak about highly qualified specialists, then in this case, work permit may be issued for the period of 3 years. If a foreigner comes to work in Russia, a foreigner must have, according to the working visa, no business visa, no tourist visa is allowed. A highly qualified specialist must obtain a fixed amount of salary, and the employer must notify the migration service on employment of the highly qualified specialist, and every 3 months the employer must notify tax inspection about the amount of salary of highly qualified specialist. Work permit is a special document. It is done in Russian language because in Russia the only national language is Russian language, and personal work permit is issued to the foreign citizen when a foreigner comes to work in Russia and applies to the immigration service. Working visa is very important for the employee working in Russia, and in case of violation of migration legislation, quite essential penalties are stated by the law. So if you need to know more about Russian labor law, if you need more information about employment of foreigners in Russia, please feel free to contact us. We shall be happy to help you. If you want to get training in Russian labor law, please feel free to contact the Academy of Open Education. Thank you and take care. Goodbye.